2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good morning. Before we have Mr. Hibner call the case, a couple of things. Your panel today is Judge Frierson from Morristown here in East Tennessee, obviously, and Judge Davis from Knoxville, and I'm Judge Swinney from Knoxville as well. If we should have any technological problems, just everybody take a deep breath and pause, and we'll count on the experts to resolve them. Mr. Hibner, call the case, please.
Melissa Ann Grayson versus Elmer Wayne Grayson.
Mr. Wilson, we'll hear from you, sir.
Good morning. Thank you, Your Honor. I represent Mr. Grayson, and of course, we are the appellants in this case. These parties were divorced back in 2011. Actually, the order was entered in May of 2011. A motion to amend was promptly filed following that order, and then in July of 2011, the court did do an amendment to its order. That amendment dealt with a couple of issues. Primarily, the original divorce decree said that one half of Mr. Grayson's military retirement pay would be given to Mrs. Grayson. That was challenged by the motion to amend, and the court dealt with that issue by saying that it'll be one half. It was his intention that one half of the benefits accumulated during the marriage would be given to Mrs. Grayson. Also, the court stated again that Mrs. Grayson was totally disabled and in need of alimony. That order stayed in place until May of 18, at which time Mrs. Grayson's attorney requested that we agree to an order that changed the language slightly from 50% of the benefits accumulated during the marriage, from one half to 50%, which is, as far as we were concerned, was no change at all. So we saw no harm in doing that if that would satisfy Ms. Grayson. That didn't satisfy her. In the fall of 18, October specifically, Ms. Grayson filed a contempt petition against Mr. Grayson because he wouldn't agree to a new proposed order that was going to give her half of his retirement, even though he had continued to work for the military to serve our country for another 6.5 years following this divorce. Clearly, back in 2011, it was the court's intention, or stated, that anything he earned after the divorce was granted was not going to be divided and would not be part of what Mrs. Grayson would be entitled to. However, this petition she filed in the fall of 18 was a contempt petition because he wouldn't agree to change it back to the one half of everything that he had earned. We bounced that around. We finally came back to court on that issue in August of 19. The court was led to believe at that time that Mr. Grayson was an E7 at the time of his divorce back in 11, and that he had had 29 years of service at that time, neither of which were correct. We immediately after that hearing in 19, when the court actually dismissed the petition for contempt, which was proper, I don't know why that was ever brought, frankly. But anyway, the court did dismiss the petition, but at the same time adopted those facts, stating that he had been an E7 back at the time of the divorce and that he'd been 29 years of credible service at that time. Mr. Grayson filed an affidavit with our motions to amend to correct those misstatements of fact. And we asked for a hearing, an evidentiary hearing on these issues. August of 20, we finally got around to a final hearing on those matters without an evidentiary hearing. And the court decided to grant her what she had asked for, 1/2 of his retirement benefits, including all those years he had worked since the divorce was granted. We appealed that to this court. The rules 5904 allow for amendments, all right, to judgments, but they've got to be filed within 30 days of the entry of the judgment. And we have a judgment back in July of 11. We have another amendment, an agreed amendment in May of 18, both stating that she was entitled to 50% or 1/2, whichever way you want to cut it, of the military retirement benefits he had earned during the marriage. Neither of those were appealed. Neither of those have had any reason for amending those at that time. We simply say that Rule 5904 says you can't come back in. The court doesn't have jurisdiction to come back in 2019 or 20, either one, and to change the order of the court that was entered in 2011, and on the very same issue, by the way. It was an issue that's forgotten back in 11. It was on the very issue that was brought before the court on that motion to amend.
Mr. Wilson, excuse me for interrupting. This is Judge Davis. So as I understand it, your position is that as of 2011, when this order was entered, your client had $0 in terms of accumulated disposable retirement.
That's correct.
And then what would be the amount of accumulated retirement as of the time that the trial court amended the order in 2020? What's the difference in the dollars we're talking about?
Well, I can't tell you exactly, Your Honor. I'm sorry to say, she's already receiving that because that order was sent on up to the military, even though we had appealed this case. And as I recall, it's about $1,000 a month, or a little over, that she's receiving at this time. And yes, it was our argument that 50% of zero is zero.
How many years did he have? It's Judge Swinney, Mr. Wilson. How many years did he have in the military at that time of the divorce?
I'm not certain, Your Honor. I know what he had at the time he retired on January the 31st of 18. He was given 2 years credit for all of his weekend warrior service, which is what a lot of his service was as in the Guard, and they only meet, certain part of the time each year. They go to summer camp and then they have weekend warriors, but he got 2 years for all that, plus the 20 years he actually served as a full-time employee of the, or full-time serviceman. So he ended up with a total of 22 years as of January 31st, 18. Now that's not, I don't believe that's in the record, Your Honor, to be honest.
Okay. All right.
The problem is we didn't have a record. Part of the problem here, we also brought to the court's attention the fact that this lady in 2012 and ever since has been living with a Mr. Brown while she was collecting $46,800 worth of alimony.
Mr. Wilson, let me interrupt. Mr. Hivner, our clock seems to have stopped.
I'm sorry.
Okay, you've got about a minute left in your time now, Mr. Wilson.
Okay, thank you. I appreciate that. We alleged that she had dirty hands, that she's not entitled to come into court asking for equitable relief. Given the fact that she's been collecting alimony all these years, while living with another man. And she also went back to work immediately when her alimony stopped, when the alimony stopped, her total disability went away. So we felt like she had dirty hands and she's not entitled to come into court and ask for anything in terms of relief. And we cite Pritchard's, or we cite the authority from Gibson Suits and Chancery to back up that defense. I'll yield the rest of my time.
All right, Mr. Wilson, you have your time for rebuttal.
Thank
Hear from you, Ms. Parsons.
Good morning, judges. This is my first appearance before you, so I'm a little nervous as well as excited. I do wish I was in court, but I understand the situations. I will keep my argument brief, as I know this court has read the appellant's brief as well as my client's brief. As to appellant's arguments that the trial court modified its orders from 2011, we feel that that is incorrect. The trial court was very articulate in reiterating from day one that it was never modifying its court from 2011. As this court, I'm sure, is well aware, when it comes to military retired pay division orders, they must be very specific. My client at that point had different counsel. For whatever reason, the orders weren't drafted to reflect how the military wanted their orders to state the division. So back in 2011, it was simply put down that she would receive 1/2 from the date of marriage to the date of the divorce. And that is what the military retired pay division order that was filed with the trial court this past year states. On the second page of that order, it does state on the date of the decree of divorce, May 11, 2011, the military pay grade was E7, and the member had 29 years of credible service. That was submitted to the court. I did go back.
Let me ask you this, and this is where I'm a little confused, because the original order in 11 said 50% or half, whichever, of the disposable retirement pay accumulated during the term of the marriage. So to me, that indicates that whatever retirement pay he had earned up through 2011 is what she would get. But then when I'm looking at the order that was sent, the military retired pay division order, it says 50% of members' disposable military retired pay. So does that mean what she's getting is 50% of everything that's accumulated up to the time of his retirement in 2018?
No, the second sentence right after that, where it says the former spouse is awarded 50% of the member's disposable military retired pay. Then it goes on to say on the date of the decree of divorce, May 11, 2011, this is what his pay grade was. And this was the amount of years that he had at that time on May 11, 2011. So, and what we have been instructed from the military is that it has to be worded that way. She is not getting, and it's our position, as it has been from day one, that my client only receives 50% from the date of the divorce, from the date of marriage through the date of the divorce, which was May 11. And as of May 11, 2011, he was an E7 and he had 29 years of credible service. Mr. Wilson states that his client did file an affidavit with the court, but he never provided any supporting documentation to support that affidavit. The court asked us, and in the court, this court can look back through the file. They did ask us to get with the military and provide to the court some type of statement from the military as to what he had. That was provided to the court. I did notice after the record went up that it was not attached as any type of exhibit, but Judge Sharp, the trial court, did see that, as well as Mr. Wilson. So that was provided to the court.
Counsel, excuse me for interrupting. Are there any transcripts from any of the hearings in this case?
There's no transcripts from any, when I became involved, which was the petition for contempt forward. No, Your Honor, there's no transcripts. I don't know, Mr. Wilson, if there were any prior to my involvement, which would have been back during the divorce.
And the order entered in May of 2018 was an agreed order. Is that correct?
That is my understanding, yes, that there was an agreement. Mr. Wilson and opposing counsel at that point entered into an agreement. Again, nothing going back to the alimony part was ever modified. So going back to, we feel the trial court did not modify its order from 7/21/2011. It basically reiterated the same position that my client received 50% from the date of marriage to the date of the divorce. And that's what the military retired pay division order reflects. As to the second argument.
Can you tell us, excuse me, Counsel, can you tell us how many years he had of service as of the date of the divorce and how many years he had for the military at the time of retirement?
At the time of retirement, I do not know, to be honest, Judge. I do know that he had 29 years of credible service as of May 11, 2011. That's what we were instructed by the military.
Is there proof of that in the record of that number?
That's what I'm referring back to. It was proffered that morning to the trial court as well as to Mr. Wilson. I was under the mistaken belief that it was entered into as an exhibit, but however, for whatever reason, it was not admitted as an exhibit.
Okay.
As to Mr. Wilson's argument about the alimony, we firmly feel that's a moot issue. That was never appealed after the last order that went down in 2011. There was a motion to reconsider that has been timely filed within 30 days. And one of those issues was asking the trial court to reconsider the alimony in paturo. The trial court put down an order in July of 2011 denying that request, and that was never brought up again until the petition for contempt was filed this past year. So we feel that was a moot issue. We don't feel there's anything about unclean hands.
Mr. Hibner or Nick, have we lost her?
It appears so, yes.
All right,
Here's it, yeah.
let's pause it. For you.
She is still in the meeting. Ms. Parsons, can you hear me? Oh, there she goes. We'll just have to wait on her to come back. There's not much I can do until.
Have y'all contacted her, told her she?
Here right now, Judge Sweeney.
Okay, thank you.
I hope she's not still arguing, unaware that no one can
I
hear.
know that was the question.
That sort of final blow at the end there, it will tell her.
Okay.
I see where she's trying to get back in right now.
I just admitted her.
Welcome back.
I apologize. I went away for some reason.
Yes, you did. All right. You can pick back up, please.
So I do apologize, judges, but I do believe that's everything that I have. Again, we feel the trial court did not modify its previous ruling of 2011. It merely reiterated through many various orders thereafter. And then as far as the alimony, we feel that is a moot issue that was not timely brought within the time period that it should have been.
Counsel, I have a question with reference to the order which was entered September 1st, 2020. At the conclusion of the order, it indicates that on the date of the decree of divorce, May the 11th, 2011, the member's military pay grade was E7. The member had 29 years of credible service, but there does not appear to be anything in the findings of fact. Did the trial court make any findings of fact with regard to that, or was that just language which was included in an order to satisfy any requirements that the pension holder would require in this order?
No, Your Honor, I do believe the court did make a findings. Like I had stated before, they allowed us to get with the military and request information via subpoena. We did do that, and that was offered to the court as well as to Mr. Wilson. And again, I thought that was made an exhibit, but for whatever reason, apparently it was not. So the court, there was a findings based upon what we submitted from the military pursuant to a subpoena.
So where is the finding of fact? Is it in the order, that last sentence in the order of September 1st, 2020?
I'm looking for that order, Your Honor. Just bear with me. So you're saying September. Let's see, I have the military retired pay division order that was filed August 31st of 2020. I'm not showing an order from September of 2020.
Well, it's dated August 31st, but the file stamp, I believe, is September the 1st, 2020.
Okay, so this court's reference in the military retired pay division order.
Yes.
Okay, Your Honor, at that point when we were in court that day, this military retired pay division order had been previously submitted to opposing counsel for the courts for opposing counsel's signature based upon what we had already offered to the court, which was the information from the military. At that point, Judge Sharp asked me if I had a copy of this order to submit for the judge's signature based upon what we had presented from the military. He at that point then signed this order in court, and that's what was done. And it was signed at that point without Mr. Wilson's signature. And so this court, when Mr. Wilson appealed, said that it had to have an order signed by Mr. Wilson. So then there should have been a subsequent identical order that Mr. Wilson signed. But no, to answer your question, there was no findings in this order. This was just the order that the military had. It's the military's order verbatim with our client's information in it.
Thank you.
Anything else, counsel? Ms. Parsons? Anything
No,
else?
I'm sorry. No.
Okay. Mr. Wilson,
Thank
I'm sorry. Thank you. Mr. Wilson, you have your time for rebuttal.
Thank you, Your Honor. To say that it's moot point that we didn't appeal the alimony issue, the issue arose after she took up with another man and has been living with him since 2012, and still is. So all we were saying was she'd been collecting alimony all this time. my client did not realize that he had an opportunity to go into court and either reduce or eliminate alimony because of her living arrangements. So to say that's moot, it's I don't quite understand that. If we were trying to appeal the original decision, yes, but we're not saying that. We're saying that the fact she's collecting this alimony while living with another man is dirty hands, and she shouldn't be able to come into court and ask for equitable relief given that circumstance. She also went back to work as soon as alimony stopped, claiming, as she did at the original trial, oh, she was totally and permanently disabled. Well, it turns out she's not permanently and totally disabled. She's back to work. So there's a lot about her credibility that we think the court should have taken into account. And the Gibson Suits and Chancery says if you come into court with dirty hands, you're repelled from the court. You're not entitled to relief. That order that was signed is 1/2 of his retirement benefits earned throughout his career. That's what that is, and that's what's happening right now. And to say that's not different, that's not an amendment to what was entered in July of 2011. I fail to understand how that argument can stand.
Mr. Wilson, is there evidence in the record of what his accumulated retirement benefit would have been in 2011? You say it's 0. Is there evidence in the record to show that?
I think the court certainly is aware of that, yes, Your Honor, because the military sent back said this is not appropriate. That until he earned 20 years, he was not entitled to any benefits, and that's the way it works in the military. If you retire with 18 years of service, as I understand it, or 19 years, you get nothing. You've got to get over that 20-year mark before you get any benefits as a retired military person. He served another 6.5 years, well, 6 years and 7 months following that July order in 2011, and he was at E6 at the time of the divorce. His affidavit shows that. We filed that with our motion to amend in September of 2019, right after the order went down, when the court said that it was 29 years of service and that he was E7. He was neither of those at the time of the divorce. There was a document that had been altered that got presented to the court one time, where somebody had handwritten in those things about the 29 years of service and E7, but the court was misled absolutely about those terms. And his affidavit, it stands unrebutted at all. Nobody argued with his affidavit when we filed it in that motion to amend, but the court paid no attention to it. Either that or just failed to see it. That's our argument. This issue was again raised back in 2011. It's not like it was a new issue. It was raised at that time, and the court made a decision that it was going to be treated like it was a 401k or something like that. That simply doesn't work. He had very competent counsel, or she did at that time. That decision was not appealed. And that order, by the way, was not drawn up by either party. The order from the July 2011 hearing was drawn up by the judge himself and filed. And neither counsel drafted that order. So that was
Mr. Wilson, I'm sorry, your time for rebuttal has expired.
Thank you very much. I appreciate it very much. We've asked that this order be overturned and the case dismissed.
Thanks to counsel for both sides. Mr. Hibner, if you'll please recess court until our next scheduled argument.
This honorable court is now in recess until 11:30 a.m.